হ্যাঁ আসানে যে আমার ছবি দেখা যায় না কেন, আমার নাম দেখা যায় কিন্তু আমার এখানে কে ঠিক করবে? আমি তো এগুলি বুঝি না ভালো করে, এখানে কে ঠিক করবে? আমার নাম আসতেছে, নাম আসতেছে কিন্তু
Good afternoon, everyone, distinguished guests, ladies and gentlemen. I am Asif Bhuiya, Assistant Counsel of Bangladesh International Arbitration Center. Thank you all for joining us today for today's webinar on alternative dispute resolution and international sales of goods, time to benefit from the CISG, which is jointly organized by Bangladesh International Arbitration Center and the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, UNCITRAL RCAP. I would like to introduce the Chief Executive Officer of BIAC, Mr. Kaiser A. Chowdhury. Mr. Kaiser A. Chowdhury joined BIAC on 1st February 2022 as its Chief Executive Officer. Mr. Chowdhury holds a master's degree in economics from University of Dhaka and is a professional banker, having started his career with Greenlace Bank, subsequently ANZ Greenlace Bank in 1975. He held several senior positions in the banking industry, including the positions of Deputy Managing Director and the Managing Director of the country's 3 commercial banks, and also officiated as the Principal of Training Institute, Dhaka Bank Limited. Currently, he is in the Board of Premier Bank Limited as its independent director. I now request Mr. Chowdhury to deliver the address of welcome, sir.
Thank you, Asif, for the introductory note. Mr. Mahbubur Rahman, Chairman, Bangladesh International Arbitration Center, BIAC. Ms. Athita Komindr, Head of United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, UNCITRAL RCAP. Webinar moderator, Dr. Shah Mohammad Hassan Habib, Professor, Bangladesh Institute of Bank Management. Distinguished speakers, Mr. Luca Castellani, Legal Officer, UNCITRAL, Ms. Sherlin Tung, Partner, Withersworldwide, Mr. Hasanullah, former Executive Director, Bangladesh Bank, the Central Bank of Bangladesh. Mr. Rizwan Rahman, President, Dhaka Chamber of Commerce and Industry. Barrister Shafayatullah, Head of Mutual Trust Bank Group Legal Affairs Division, and respected members in the audience who have most eagerly registered themselves to participate in this webinar. It is from Dhaka, Bangladesh, that I wish a very good afternoon to all of you stationed across different time zones, stretching from Incheon to Vienna. On behalf of BIAC, it is my proud privilege to welcome you all to this much awaited webinar. The event has been organized at the initiative of UNCITRAL and culminating in a joint collaboration of UNCITRAL and BIAC. Alternative dispute resolution and international sale of goods. Time to benefit from the CISG? It is the webinar's subject for deliberation and has been found to be most appropriate, relevant as it is from the Bangladesh perspective. The United Nations Convention on Contracts for the International Sale of Goods, CISG, is a widely adopted document that establishes due legal framework for international sale of goods related contracts. We are informed that CISG is the only legal text dealing specifically with cross-border trade transactions and has been adopted by 94 states, covering more than 80% of the global trade. We are further informed that the countries in South Asia, Bangladesh included, have remained outside the orbit of CISG. It is precisely in this context that today's webinar gains its significance. We are appreciative of UNCITRAL for selecting BIAC to co-host this webinar. We are even more grateful to the esteemed moderator and the distinguished speakers for taking time off to participate and provide their precious thoughts and idea inputs. These, coupled with due clarifications to the queries that may be raised by the registered audience, should lead us to take the initiative to establish an efficient framework for dispute resolution and play our due role to ensure that Bangladesh opts to be within the fold of CISG sooner rather than later, to improve efficiency in supply chain management and increase the offer of legal services, including those related to ADR. Thank you. And once again, a very warm welcome to all of you. Now, it is back to you again, Asif.
Thank you very much, Mr. Chowdhury, for your address of welcome. Now I would like to introduce Ms. Athita Komindr, Head of UNCITRAL RCAP. Ms. Athita Komindr is the Head of UNCITRAL Regional Center for Asia and the Pacific. She has over a decade of experience in the fields of international trade and economic law, arbitration, multilateral dispute resolution, and the rule of law and development. Prior to joining United Nations, Ms. Komindr mainly advised and worked with numerous agencies in Thailand, including the Thailand Institute of Justice and the Thailand Arbitration Center. She also worked for the Thai Ministry of Commerce in Bangkok and Geneva, representing Thailand in bilateral, regional, and multilateral trade negotiations, WTO dispute settlements, and treaty drafting. Admitted to the New York Bar since 2002, Ms. Athita Komindr has experience in both common and civil law traditions in the public and private sectors, and holds degrees from Harvard College, Georgetown University Law Center, and the Harvard Law School. I now invite her to deliver address of welcome. Ma'am, please.
Thank you very much for that kind introduction, Asif. Please allow me some moments to share my screen. I'm currently disabled, so if I could be enabled.
Yeah.
Thank you. Okay, I'm still disabled.
Just a second.
Thank you.
Okay, all right, we will share the screen. We will share the slide. All right.
All right. Okay, well, thank you very much. I will give you a verbal cue then.
Yeah, no. I'll be there
Thank
to
you.
assist. Yeah.
Thank
Okay.
you. So Mr. Kaiser A. Chowdhury, Chief Executive Officer of Bangladesh International Arbitration Center, distinguished moderator, speakers, and participants, greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, or UNCITRAL RCAP in Incheon Republic of Korea. It's an honor to deliver co-welcoming remarks to this UNCITRAL RCAP BIAC webinar, with special thanks to the wonderful organizing team at BIAC. I note that this is our second joint webinar. The first, held last April, focused on how enforcing contracts via UNCITRAL instruments makes doing business easier. Today's webinar is another dimension of that theme, as my colleague, UNCITRAL Legal Officer Luca Castellani from Vienna, and international legal expert Sherlin Tung will elaborate. The United Nations Convention on Contracts for the International Sale of Goods, or the CISG, is one of the most successful tools for facilitating trade. The predictability fostered by the CISG is well known, as it contains a complete and balanced set of default rules covering the most common issues arising out of cross-border sales. Adoption and use of the CISG contributes significantly to introducing certainty in commercial transactions and decreasing costs, thus facilitating cross-border commerce. Next slide, please. Making it easier to do business is the core work of UNCITRAL. As the core legal body of the United Nations in the field of international trade and commercial law since its establishment by the General Assembly in 1966, UNCITRAL's mandate is to promote the progressive harmonization and modernization of international trade law in order to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. UNCITRAL texts are negotiated with the involvement of a variety of states representing different legal traditions and levels of economic development. This helps ensure UNCITRAL texts are widely acceptable as offering solutions appropriate to diverse jurisdictions. Next slide, please. UNCITRAL legal instruments, whether they be treaties, model laws, or legislative guides, recognize that different legal regimes may constitute a transaction cost and risk to doing business. Uniform legal treatment of these instruments across jurisdictions ensures predictability and fair treatment and promotes long-term engagement and the sustainable creation of value. The need for modernization and harmonization of international trade law via UNCITRAL texts is particularly compelling for sustainably adapting to our new normal. UNCITRAL instruments are also useful as they cover the lifespan of a transaction, starting with deal making via the CISG, today's focal instrument. The year 2020 marked the 40th anniversary of the CISG, meaning that since 1980, the convention has been providing a modern, efficient, and neutral legal framework for all aspects of international sales contracts, from their formation to the obligations of the buyer and seller and remedies for breach. The CISG has been adopted by 94 states of all regions, economic and legal systems, with Portugal being the most recent. In addition, 13 out of the top 15 global exporters and 12 out of the top 15 global importers are CISG contracting states. And the CISG applies to over 80% of the global trade in goods. Next slide, please. Adoption by diverse states from different geographical regions and legal traditions are testament to the universality and versatility of the CISG. For example, the Democratic People's Republic of Korea acceded in 2019, followed by Liechtenstein, Lao PDR, and Guatemala also in 2019, and Portugal in 2020. Next slide, please. The CISG has been enforced in several Asia-Pacific states for at least 10 years, including in China, Australia, New Zealand, South Korea, and Japan. With the onset of One Belt, One Road, the CISG will only become more prominent in the Asia-Pacific region and beyond. UNCITRAL is also following with great interest the application of the CISG to Hong Kong SAR, especially as the ordinance to implement the CISG in the jurisdiction was passed on 29 September 2021 and is envisaged to take effect in the third quarter of this year. Several other jurisdictions in the region are also considering the CISG. The Philippines and Thailand, for example, have been seriously discussing for several years and may soon take action, while deeper engagement in Indonesia and Turkmenistan is more recent. Next slide, please. Turning to CISG jurisprudence and scholarship, more than 5,000 decisions applying the CISG have been reported. In addition to courts, arbitration institutions are an excellent source of case law. In fact, many of the 1,000 global CISG cases in the Case Law on UNCITRAL Text Database, or CLOUT, are from arbitral institutions from different jurisdictions. Additionally, countless books and articles have been published on the CISG in a broad range of languages. The text of the CISG is also easily accessible in all 6 official languages of the United Nations and several other languages. Detailed information on the CISG, including UNCITRAL materials, CISG-related jurisprudence, and arbitral awards from around the world, and lectures from the UNCITRAL Secretariat, can be found on the CISG at 40 webpage shown on your screen. Next slide, please. Before we end, allow me to introduce my office, UNCITRAL RCAP, which was established in Incheon, Republic of Korea in 2012 and is UNCITRAL's only regional center. Supported by the South Korean government and also Hong Kong SAR China, including via secondees from the Korean Ministry of Justice and Hong Kong SAR Department of Justice, the regional center carries out UNCITRAL's mandate in approximately 60 jurisdictions in the Asia-Pacific region, working with governments, the judiciary, academia, and other stakeholders. Since RCAP was established in 2012, with Luca being the first head of office actually, the majority of AP jurisdictions under RCAP's coverage have adopted at least one UNCITRAL instrument, ranging from the CISG to e-commerce, access to credit, and dispute resolution, greatly contributing to legal harmonization both regionally and globally. Next slide, please. I invite those interested in learning more about UNCITRAL to take UNCITRAL's first online training course. This interactive and self-paced course introduces users to legal harmonization, UNCITRAL's methods of work, and how UNCITRAL texts contribute to the achievement of the Sustainable Development Goals. Currently available in English and Chinese, the 3 modules are the first of a forthcoming series. The course is available free of charge on the UNCITRAL website, and an electronic certificate is downloadable for users who complete all 3 modules. Next slide, please. For more information on the work of UNCITRAL RCAP and UNCITRAL, please peruse our webpage and subscribe to our mailing list. And do feel free to directly reach out with questions anytime. Thank you very much for your attention. Thanks again to our co-organizers, BIAC. RCAP looks forward to continuing collaboration with Bangladesh institutions and government agencies on many more important activities like this one. Thank you.
Thank you, Ms. Komindr, for your address of welcome. Our moderator for today's webinar is Professor Dr.
Asif, you have been muted. Asif, can you unmute, please?
Sorry. Thank you, Ms. Komindr, for your address of welcome. Thank you. Our moderator for today's webinar is Professor Dr. Shah M.D. Ahsan Habib. Dr. Shah M.D. Ahsan Habib is a professor of the Bangladesh Institute of Bangladesh Management, BIBM, and independent director of IPDC Finance Limited. He obtained his PhD from Banaras Hindu University, India, and postdoctoral fellowship from Syracuse University, USA. With over 25 years of professional experience in the banking industry, his key research areas includes financial crime and money laundering, inclusive finance, green banking, bank leadership and governance, and trade financing. He has been a teacher at Dhaka's Institute of Business Administration, IBA, and University of Dhaka, among others. Dr. Ahsan is a columnist of national dailies, authoring features on financial crime and banking issues. He has worked as a research consultant with several national and international organizations. Dr. Ahsan is also a member of ICC Bangladesh Banking Commission. I now request our esteemed moderator to take over and conduct the session proceedings. Ladies and gentlemen, Dr. Shah M.D. Ahsan Habib, sir, over to you.
Thank you, Mr. Asif, for the nice introduction.
You're welcome.
Yeah, good morning to the delegates of Vienna, and good afternoon for the participants of the South Korea and Bangladesh. Honorable Chairman of BIAC, Mr. Mahbubur Rahman, I think sir would be joining. Then we have CEO BIAC, Mr. Kaiser Chowdhury. Then we have with us Head of UNCITRAL Asia Pacific, Ms. Athita Komindr. Respected panel speakers from home and abroad, let me welcome you all to the panel discussion section of this particular event. Distinguished listeners, we have already heard from our hosts. They have rightly pointed out the importance of efficient alternative dispute settlement and adoption of CISG. And we all are aware of today's topic, that is alternative dispute settlement and international sale of goods. And we will be basically focusing on CISG, or what is popularly called as UN Vienna Convention on Contract of Sale. We all are aware that the legal enforceability of contract is particularly crucial in the cross-border trading, where alternative dispute settlement and CISG have great roles to play. Over the years, we have been struggling to draw attention on the issues. Yes, during COVID-19, traders and policymakers started realizing the importance of these issues. That is a positive sign. Ladies and gentlemen, We have got two segments of this panel discussions. One is international part and another is national segment, domestic part. And we want to start with the international segment. Let me first invite our international speaker, Mr. Luca Castellani, who is a legal officer at UNCITRAL. Luca is having LLM from New York University and a PhD from the University of Trieste, Italy. Having a good number of published articles on trade laws, he started his career with the UNCITRAL in 2001, and he was the first head of the UNCITRAL Regional Center for Asia and Pacific. Let me request Luca. We'll be expecting CISG perspective and the associated benefits and opportunities. Over to you, Luca.
Thank you very much, Hassan, for this very kind introduction and a very warm good afternoon from Vienna, Austria to all of you. I would like just to say it's not only a real pleasure and an honor to be here, but I also would like to stress that this is particularly important as we have seen already several calls from colleagues in Bangladesh to have more information about this convention, which is truly a flagship convention on international trade. And so it is really so important to start this discussion. And I think it is particularly appropriate to start it now with you. And of course, we acknowledge the very important support of the BIAC. So if I may ask the organizers to start sharing my presentation. So thank you. So we go to the next slide. Next slide, please. Thank you very much. So now here I have my task is greatly facilitated by what has already been said, including by my dear colleague Athita Komindr, about the current status of the CSG. We have already said this is a treaty that is compatible with all legal systems. Actually, it was adopted in 1980, but it is quite known that it has been drafted for decades. The work on this treaty started already in the 1930s, before World War II. And it took all of this time, and there were also, of course, intermediate steps, and other conventions were adopted, namely in 1964, going towards this outcome. So we can say really the CSG has been a labor of love, if you want to see it that way, with very important and innovative features, and very much a fit for the intended purpose. But especially this has been a very inclusive process. And one of the reasons why it was concluded in 1980, because all the work that has been done until the 1960s had to be reviewed in light of the need of developing countries and newly independent countries. So this I would like really to stress that there has been a really significant input from those that indeed were back then newly independent countries, and to make sure that CSG is compatible with all legal systems. So it's not just civil law and common law, but for instance also Islamic law. For instance, back then socialist law was of course prominent, and this was a main feature. Now when we look at the actual distribution of these 94 states, this is where I am a bit bothered, because I always say CSG benefits are mostly for developing countries, but we have there mostly developed countries. Most of these countries are in the Northern Hemisphere. We are larger economies. For instance, we have all European Union member states, but 2. And then there is this issue, which in my opinion, it has mostly to do with a coincidence. There is no design, but it so happens that if we look at the big sub-regions in the world, we have more or less every sub-region covered with at least one state party to the CSG, but we don't have in South Asia, which is very strange because CSG applies to, in principle, to more than 80% of the goods exchanged across borders. And of course, South Asia is a big economic player in the global economy. Next slide, please. I will try to focus on a few selected issues of the CSG. It's not possible to cover, of course, all the substance, not even possible to give an overview of the substance. First thing that I would like to stress is the CSG is an enabling treaty. When we think of treaties, we always think of mandatory application of law. And this is not what is in the CSG. The CSG is an additional tool to make the life of business people easier and to help them in producing wealth and in helping, of course, economic development, social development, for instance, expanding employment and so on and so forth. So it works in a way that is different from the treaties we usually look at. It applies, of course, under its own scope of application, but then it gives the parties the possibility to opt out or to vary any of its provisions. So it is a safety net. When the parties are unaware of which law should apply because they didn't spend time thinking about it, or where the parties disagree on which law will apply, because naturally in cross-border transactions, each party wants to have its own law because they are more familiar with it, then comes the CSG as a neutral and fair playing ground. But the core principle of the CSG is the principle of party autonomy, which means exactly that the parties are free to decide on a different applicable law, on a different contractual arrangement. And I repeat, this is perfectly fine. This helps to have all the states in the world agree on the effect of party autonomy. So it's really important. At the same time, we have seen in the past, and we see it less and less, a trend of comfort. You know, lawyers had a comfort zone. So in certain large jurisdictions, they would say, let's opt out of the CSG and let's use our law. And of course, this trend is not professional. Actually, on the contrary, it may expose to professional liability, because there are many cases in which the CSG is the best solution for the client, and there are many cases where it's not. And where it's not, and opting out is justified, this is perfectly fine. But where it is, then the specialist of international trade law must advise the client on the benefits arising from the application of the CSG. Next slide, please. That's exactly what I say when I say that there is increasing awareness that the CSG is a must-have in the legal toolbox. And that's what we will hear soon from Sherlin Tung about the reasons behind the support for the extension of the territorial application of the CSG to Hong Kong. Hong Kong, of course, a major hub for trade, for legal services, for dispute resolution, and also shares the same common law heritage as Bangladesh and other countries in South Asia. So far, CSG was very popular in mainland China, but was not applied to Hong Kong because of historical reasons. But now Hong Kong says we want to be as competitive as others. To name one, Singapore. And that's why we're going in this direction. It's important also to internalize the fact that the CSG complements both free trade agreements and regional economic integration movements. So we see that in the European Union, we see that, for instance, in North America and in Latin America. With respect to Asia, we see that as an aspiration in ASEAN member states. So for many years, Singapore was the only country that had adopted the CSG. Then came Vietnam, then came Laos. Athita has already mentioned that the discussions are quite advanced, both in Thailand and in the Philippines. So little by little, we see that this is gaining momentum. Next slide, please. This is more, let's say, from a perspective of practice, but also with the pinch also of academic contribution. If we look at what is going on at the global level, we see that there is awareness and there is support for promoting and upholding, in general, freedom of contract, that is to say, parties should be free to enter in contracts, and then also party autonomy, which means parties should be free to adapt the contract to their needs, which has important implications for private international law when it comes to choice of law and choice of forum. And by choice of forum, I also include, of course, the arbitration clause and the possibility to have ADR. This is convenient because, and here I have to say, Bangladesh is, of course, a powerhouse in the global supply chains, especially for manufacturing and exporting goods. So it is the originator of many of these global supply chains that, of course, are business to business until they go to the country where actually the goods are sold to consumer. And ideally, one should be able to allocate risk and manage with the supply chain in a manner which is coherent. Aspirationally, I would say, applying as much as possible the same law, or anyway, applying laws that are compatible. And of course, uniform law seems to be the obvious solution here, because it's law that is already compatible with all legal systems and that each legal system may adopt or enact, depending if it's a treaty or a model law. As I said before, because the CISG main goal is to combine predictability and flexibility, this gives us the possibility to provide a uniform legal framework for these cross-border supply chains and to increase governance, especially to increase efficiency. And here, let me just refer to this publication, which actually is quite recent. It was issued just a year ago. So this legal guide to uniform instruments in the area of international commercial contracts with a focus on sales, which is available in 6 languages of the United Nations from the websites of the 3 organizations that jointly prepared it, which is to say UNCITRAL, together with UNIDROIT in Rome and the Hague Conference on Private International Law. So it covers the 3 main aspects, the private international law aspects, including the Hague principles on choice of law, the contribution of UNCITRAL and its core being the CSG, and then the very important contribution, of course, of UNIDROIT with the UNIDROIT principles of international commercial contracts. These are texts that are different in nature. CSG is a treaty. The others, of course, are principles. They can be maybe used contractually, but all of this is very coherent, and it's really important for specialists to understand how things come together. Next slide, please. I have to say something about the pandemic. Of course, we see the world is really shaken by different shocks, which have a major effect on trade. So this is just to reinforce my case on the need to have a coherent governance of supply chains. I have to say the recovery from the pandemic is very much axed around the digital transformation, and of course, and also the green transformation. So it has to be environmentally friendly, but it has also to be very innovative. Where does the CSG stand on this? Well, the CSG has a general principle of freedom of form, which allows to accommodate broadly the use of electronic means And here I would like to stress that Bangladesh has already adopted an Electronic Transactions Act, which is based on the UNCITRAL model on electronic commerce. And now it is incredibly active in the digital scene. We see now that there is significant interest in further updating legislation, and we hope there will be chances to cooperate also on that front. But if someone is interested, there has been a recent stock-taking exercise, which is the UNCTAD Rapid Trade Readiness Assessment, which is also available for free in the web. So very much CSG ready to accommodate digital issues, and of course, very much also CSG ready to support green and social standards. Now, before we used to talk about corporate social responsibility, we still do that. It's very important, but we can go also a little bit beyond now. We talk about environmental, social, and governance standards, ESG, and that gives a broader dimension to the social responsibility, or especially of large companies. Next, please. So the question may arise at this point, this is all good and well, but in practice, why should we adopt the CSG, and what's in it for us? Well, as I said before, we have basically two options, and these options may be different, especially depending on the size of the business, because we're also mindful that on the one hand, small and medium-sized enterprises are actually provide the bread and butter of the economy. They are really the engine for day-to-day survival for millions of people. But of course, they also have limited resources and limited access to qualified legal advice. So they may be more in a condition that when they conclude contracts, not to have too many details, and maybe they don't have a choice of law clause, for instance, or even a dispute resolution clause. So if in case of dispute, in which it may be already litigation or arbitration, but can be just also before that, we have to find out what's the applicable in order to find out who's right, who's wrong, and how to conform with the contract. And of course, the fact that the CSG applies as a default helps us immensely. And as we will see, this helps also preventing forum shopping, because if the CSG applies in the different countries, then the outcome of dispute resolution should be the same regardless of the forum. But if we do have the possibility to discuss applicable law in the contract, and it's really important, of course, to align choice of law and dispute resolution so that it would be coherent, then the parties may find it easier to agree on the CSG because it's uniform, it's neutral, it's international, it's available in so many languages, and has a very broad academic and case law amount of information available. So that's much easier. Next, please. So you see here a summary of what I said. So why is it particularly good for ADR? Now, Sherlin, of course, will elaborate on that, but all the ADR specialists can see why CSG is so often chosen and applied in arbitration. Everyone knows it, it's familiar, it's modern, it's fair, it's neutral. It has all the features that we want to have. What is interesting here, and I will not go into the details, but I just wanted to signal this issue, is that the CSG, of course, can be applied by choice under its own scope of application, but often we see it applied in arbitral proceedings with other mechanisms. Sometimes it's possible as appropriate law, sometimes it's possible because of the terms of the arbitration, because it is given to the arbitrators the possibility to identify the applicable law, and then they are more comfortable going to the CSG than going to any national law. Next, please. As I said before, we don't leave countries alone when they decide to apply the CSG. As mentioned already, it's available in the 6 UN official languages, but in many more actually with official and unofficial translations. We have more than 5,000 reported cases applying the CSG, which is quite meaningful. Now, I just want to say how many reported cases we have applying any national sales law. I think very, very few countries can say 5,000. And we have quite a few tools available. One of them is the case law on UNCITRAL text database, which is available for free from UNCITRAL in the 6 languages. There is also a digest of case law, very interesting. And it's more than 500 pages long. And it really gives all the relevant case law for each article of the CSG, highlighting the main interpretative trends. There is, of course, a duty of uniform interpretation of the CSG. We didn't have the time to go there. And there is the possibility to find out what other countries are doing. And so it's possible for judges and for lawyers to know what is the prevailing trend and to go according to that trend as the CSG requires. But I'm also very, very happy to report that out of the 101 articles of the CSG, the points where there are some discussions are extremely few. And those are mostly not because of the CSG, but because of differences in legal systems that may have an impact on the CSG. Next slide. I would like to conclude by stressing again the importance of including developing countries in the CSG. When the CSG was concluded in 1980, facilitation of equitable trade has been a main goal for completing this work task. And this is reflected in the preamble of the CSG. There is also some specific guidance on certain matters. This is, for instance, CSG has a mechanism for remedies for partial performance or non-performance that foresees the engagement of the parties in cooperation in order to reduce economic losses and to keep effects of the contract as much as possible. But when we look at the travaux préparatoires of the CSG, we see that the drafters have taken into account the fact that this mechanism may be implemented differently in developing countries, because there is maybe not the same level of expertise or is not so easily available, or is a different cost. What is very unfortunate, in my opinion, is exactly where the CSG is least adopted, where it may be needed the most. So I'm very happy that we're having this conversation here today, because Bangladesh really, because of its role, especially in manufacturing goods, could really get significant benefits from adoption of the CSG, maybe can also show the way to other countries in South Asia. I thank you very much for your attention. I was extremely privileged that I had an additional 5 minutes by starting a little bit early. Of course, I took full advantage of it, which is a bit dishonest on my side, but you know, it's so nice to be able to talk to you. And of course, I had absolutely to take advantage of this. I apologize. I should have shared this bounty with Sherlin, but I didn't.
Thank you, Luca, for your very lucid presentation and letting us clearly understand the importance of CISG, its inbuilt flexibility and potential benefits of adopting CISG, along with its capacity building tools. Thank you very much. Now, let me proceed to our second speaker of the international segment. We have with us Ms. Sherlin Tung, who is a partner at Withersworldwide, Hong Kong. Sherlin is a specialist in cross-border disputes, international commercial arbitration, and multi-jurisdiction litigations. She worked for ICC International Court of Arbitration in both Hong Kong and New York. During her time at the ICC, she managed over 300 international arbitration proceedings. Sherlin, please enlighten us with your experiences with international arbitration and cross-border disputes. Sherlin, please.
Okay, so everyone's going to have to bear with me. Even 2 years into this pandemic, I still find myself often being on mute during presentations or meetings and also experiencing technical difficulties. So I have been allowed to share my screen. Gives me I think it's this one. Does this mean you see my appropriate screen where you see the entire slide? I'm going to need somebody to kind of nod at me, or actually don't nod because I can't hear you.
Yes, we can see.
Perfect. Thank you. Okay, so Luca, I'm very happy that you took extra time. I would have been happy for you to take even more because you are the expert on the CISG. What I have been asked to do today is kind of give a little bit of a background on the CISG, its development in Hong Kong, and you don't necessarily see it on the title, but also kind of the interactions with arbitration, the benefits, or basically what's up with the CISG and arbitration. So hopefully I will be able to give all of this in a good nutshell. I'm going to figure out how to do all of these different slides. I think I hit next slide here. Well, I don't really think we need to go into any of the CISG background or brief introduction in detail, given that we've already had previous speakers give a good explanation, but I don't think it will ever be too much to reiterate the basic introductions or the basic background of the CISG. As you've already heard, it's been ratified by 94 countries as of 2020. This constitutes about 2/3 of the global economy, which is quite important. Among this list, as Luca, I think, referred to a bit earlier, the top APAC economies such as China, and I have to specify mainland China, Japan, Singapore, and the Republic of Korea are signatories of the CISG. Now, as you know, the CISG is an international treaty that does aim to facilitate the international trade. The CISG, again, just a friendly reminder, applies solely to international sale of goods contracts. That means that certain contracts would not fall under the scope of the CISG. The CISG is automatically incorporated into the domestic laws of contracting states, and it's automatically applicable to the sale of goods between parties with place of business in contracting states. Now, contracting parties, which is something which we often inform our clients, have the ability to expressly exclude the CISG's application to their transaction, or another benefit is to modify the rules established by the CISG within the party's contract. Let's skip to the next one. I'm going to actually jump straight into the CISG and arbitration, just to kind of give you a bit of a background. With the rise in international transactions, there's also a rise in international disputes. Now, disputes in relation to international trade are often resolved by means of arbitration, and there's a variety of reasons for this. The main reasons are because of the neutrality. Arbitration will take a dispute out of the alleged bias of certain national courts because you have two parties from two different jurisdictions. But arbitration also offers a variety of other safety factors such as confidentiality. Oftentimes we can argue that it's faster, depending on certain jurisdictions. For example, if you had a dispute in India and you were to submit it to a court, it would take significantly longer than it would likely take in an arbitration. Now, the CISG, as Luca referred to earlier, also has a benefit in that it does, in a practitioner's opinion, offer neutrality to parties who are from different jurisdictions and who are entering into an international sale of goods contract. Now, how do you know if a CISG is applicable in an arbitration? Well, generally, you have to take a look at what the parties' intentions are. There's usually an express reference to the CISG in the contract under the governing law provision, or there's an express reference to the law of a contracting state in the contract. However, oftentimes we see in the real world, parties often forget to indicate what law will govern that particular contract. And in that type of a situation, when you find yourself in an arbitration under the leading arbitral institutional rules, the governing law is determined by the arbitral tribunal as the appropriate rule of law. Now, this is seen in, for example, the ICC and to the AIAC, which is the arbitral institution in Malaysia. It's also seen in the other leading arbitral institutional rules. Now, the interesting thing about being able to use the CISG in arbitration is that there are debates and good arguments out there that the CISG can apply not only to the substance of the dispute, meaning the merits of the dispute, but now there's an argument, or there are courts that have applied the CISG also to the procedural aspect of the arbitration, mainly to whether or not an arbitration agreement has been concluded between the parties, or how an arbitration agreement can be interpreted during a dispute. Now, what we always inform our clients is if they are not sure whether or not they want to apply the CISG in their contract, they should always, for the avoidance of doubt, expressly exclude the applicability of the CISG in their contract, but we don't actually recommend this. And the reason for this is also, again, as another benefit to arbitration, as another benefit of arbitration, the CISG also has the benefit of familiarity. Parties who are entering into cross-border contracts or international sale of goods contracts will not necessarily know the relevant laws of the other side's jurisdiction. However, if you agree to apply to this or apply the CISG to your transaction, to your international transaction, you will be familiar with what laws will govern various aspects of your contract, whether it's the formation of your contract, whether or not you have the ability to avoid or terminate a contract, what damages or remedies that you are subject to under this particular contract, because the CISG sets it all out and sets it quite clear. Now let's talk about the CISG in Hong Kong. There is one thing I actually have to disagree with Luca on, and I think he already anticipated it. The issue with Hong Kong is, as everyone knows or should know, Hong Kong used to be a territory of the UK. The United Kingdom is not and was not a signatory to the CISG. So up until 1997, the CISG never applied to contracts where the law governing the contract itself was Hong Kong. However, once the handover occurred in 1997, there actually was a question raised as to whether or not the CISG could govern such disputes. Now, the reason for that is because mainland China is a contracting state to the CISG. However, during the handover, the CISG was not listed in one of the various treaties that would be extended or applied to Hong Kong. So for a long time, it actually remained uncertain as to whether or not the CISG applied in Hong Kong. In particular, whether the convention applied when a party was from Hong Kong, when a party from Hong Kong was involved in the dispute, and this is under Article 11A of the CISG. And the courts actually worldwide have been split. I've listed two examples here. For example, just recently in January of 2022, a court in the US held that the CISG did apply to a contract that involved two parties, one from the US, New York, and the other was a Hong Kong-based and Hong Kong incorporated company. So in New York State Department of Health versus Rusi Technology Company, there was a question that arose as to whether or not, or what the applicable law was. And this was over the sale of surgical or masks. And basically there were two contracts at issue. There was a contract that was written in Chinese, and there was a contract that was written in English. Now, both contracts, apparently the lawyers, another piece of advice for when you are giving advice to your clients who have bilingual or even trilingual contracts, always make sure that every contract matches one another. In this particular situation, the contracts didn't. Basically, the main thing that was missing, or at least that is applicable to this situation, was the governing law. Now, the English version the Chinese language text stated that basically the domestic Chinese law would apply and that the CISG was excluded. Now, this wasn't taken into consideration or even mentioned in the English version of the contract. So interestingly enough, when this case went straight to the New York court, there was also an arbitration agreement providing that CTAC would resolve any and all disputes. But again, this was not in both versions. This was in the Chinese language text. So when the case was brought before the New York court, one of the parties objected that the court proceeding should be stayed and it should be kicked out to arbitration because of the arbitration agreement that existed. Now the court had to first take a look at what law governed the contract. And the court ultimately found that the CISG applied to the contract because it was not clear that the parties had expressly excluded the CISG, and because New York is a part of the US, a contracting state to the CISG, and Rusi Technology, which was headquartered in Hong Kong, was technically Chinese and also therefore a party to the CISG. The CISG applied. So in this particular case, the court, without getting into any politics, basically found that Hong Kong, where the place of business was a signatory or a contracting party to the CISG by virtue of the fact that Hong Kong is a territory to China. Now, on the other hand, you've got a very also long line string of cases that have found the other way, where the courts have found that a company who is seated or based in Hong Kong would not be deemed a contracting state of the CISG. And the leading case on this, from my understanding, is Logicom versus CCT Marketing Limited, which came out of the Paris Court of Appeal. Now, another question as to whether or not the convention would apply is when the rules of private international law of the forum lead to the application of Hong Kong law. And if it is Hong Kong law, would the CISG apply under Article 11B because Hong Kong is a territory of China? Again, we've got the diversifying opinions, but it has been seen worldwide that courts have gone both ways. Now, the question seems to have been answered already by the Hong Kong Department of Justice, or LegCo, because Hong Kong, as I will go to my next slide, in September 29th, 2021, they enacted the Sale of Goods Act. And this was done after quite a long period of consultation. The previous year in 2020, for 8 months, the Hong Kong DOJ invited various parties worldwide within the community of Hong Kong, as well as outside, to comment on this proposed ordinance. The reason for this comment, the reason for the invitation of comments is it's common in Hong Kong. Every time such type of a ordinance is proposed, they first invite the communities, the relevant communities and professionals to make comments to see whether or not the proposed ordinance needs to be tweaked. Now, during this period of consultation, there was overwhelming support for the Sale of Goods Ordinance to be implemented. And that's why on 29 September 2021, Hong Kong LegCo went ahead and implemented it. Now, the Sale of Goods Ordinance seeks to implement the CISG in Hong Kong. And the Hong Kong Department of Justice has announced that the CISG ordinance will come into force in or around the third quarter of 2022. Now, the reason why I say that the Hong Kong DOJ has basically addressed this ambiguity of whether or not the CISG applied prior to the implementation of the Sale of Goods Act is because the Hong Kong DOJ specifically stated that no, the CISG did not apply in the territory of Hong Kong until the passing of this ordinance. Now, once this ordinance comes into force, the Hong Kong courts will apply the CISG, but it's important to note, and I'll explain a little bit why, they will apply it not only in a situation of Article 11A, meaning where both parties to a dispute are from, have places of business in a contracting state, but the Hong Kong courts or Hong Kong jurisdiction itself, unlike that of China, will also apply the CISG in a situation where it's Article 11B, meaning after an analysis of what private international law would apply, if it is Hong Kong law that will apply, the CISG will apply, even if only one of the parties has a place of business in the contracting states. Now, the community here in Hong Kong has actually, like I said, been quite welcome to the implementation of the CISG here in Hong Kong. It's especially helpful to the small and medium-sized firms because the CISG, in our opinion, will protect local businesses from being subject to unfamiliar foreign laws when entering into cross-border sale of goods transactions. It also allows the businesses to have an additional choice of law. Now, the reason why this is quite good, Hong Kong is a very international jurisdiction. Even with the COVID pandemic, even with all of the developing situations, there's no doubt that Hong Kong remains one of the leading centers for commercial transactions, commercial disputes. It is a gateway to China, but that also means that there are a variety of different companies that are going to enter into transactions with Hong Kong companies. And that requires that the Hong Kong companies be familiar with various types of laws. By implementing the CISG, which is familiar already to 94 other contracting states, it is a familiar law that Hong Kong companies can agree upon with other companies. And also in a situation where the governing law isn't chosen, it is a good default. Well, it's a default, but it is good for the Hong Kong community because they will be familiar with what types of law will govern their particular transaction. Now, the CISG doesn't automatically apply to domestic transactions between mainland Chinese and Hong Kong companies or businesses, but in the past, we have found that the CISG has actually been applied to such transactions, particularly in arbitrations. But not only that, there are currently discussions between the mainland Chinese government and the Hong Kong government to implement a mutual arrangement. These mutual arrangements are quite common in Hong Kong. We already have a number that are relevant to this discussion. For example, Hong Kong and mainland China have a mutual arrangement on enforcing arbitral awards. Even though Hong Kong is a territory of China, it is important to note that there is a one country, two jurisdiction system. Basically, Hong Kong is a common law jurisdiction, whereas mainland China is a civil law jurisdiction. In the past, there have been difficulties with awards and judgments in Hong Kong from being implemented and enforced in China and vice versa. But in the last 5 or so years, or even decade, Hong Kong and China have eliminated this discrepancy or these difficulties by applying a variety of mutual arrangements. Now, the CISG is not next in line, I'm sure, on a long list of things, but the discussions are that it will be mutually applied between the two countries. Now, the reason why we say, or the reason why the Hong Kong DOJ has said that they expect the Sale of Goods Ordinance, or the CISG, to be applied in Hong Kong in the third quarter of 2022 is because Hong Kong is still waiting for mainland China to declare declare the extension of the CISG to Hong Kong to the CISG depository, and that is actually expected later this year. Now, again, potential benefits of having the CISG here in Hong Kong, and I've already mentioned it before, but it's really important to stress. It enhances Hong Kong's role as a leading seat for resolving commercial disputes. It also enhances Hong Kong's role, or it further reinforces Hong Kong's role as a leading place for international cross-border sale of goods transactions to take place. Having the CISG here in Hong Kong would also reaffirm neutrality, consistency, and stability, because all of the parties involved in such transactions will be familiar with the specific law. There will be more trade and shipping related arbitrations involving Hong Kong parties, and those disputes, if any arise, would be resolved according to the CISG. Now, the fact that we've now extended the CISG to here in Hong Kong also enhances the local lawyers' competence in handling and managing CISG related disputes. And again, as this was mentioned before, it's an even greater potential for Hong Kong to serve as a dispute resolution hub for members of the Belt and Road Initiative. Now, talking about CISG just kind of in the APAC region, again, in spite of the pandemic and in spite of all of the developing situations, the world continues to see an impressive growth in Asian economies. A lot of these countries and regions are very close trading partners to Hong Kong, for example, Singapore, Korea, and Japan, and also mainland China. And there's an increasing need again for the uniform or harmonized law in commercialized matters. This is what will make it familiar for all parties involved, and this is what will strengthen Hong Kong as a commercial seat. While the number of Asian contracting states are still limited, we're starting to see this develop in a positive way. For example, why we have today's webinar. Asian countries are taking more and more of a role, or an active role, in these cross-border international transactions, and the need to find a unifying, harmonizing law is important, and the countries and the governments are taking note of it. Now, finally, again, the adoption of the CISG by Hong Kong is going to greatly assist our businesses in connecting with and smoothing any dispute resolution with their trading partners in the region and in a worldwide context. So just to kind of leave you with one quick note that I do always advise my clients, I have a number of clients that are based in mainland China. I have a number of clients that are based in Europe, in the US or other parts of Asia. And they always ask me, why is the governing law so important? As you guys hear, the arbitration agreement is almost always this midnight clause, but oftentimes the governing law provision or the governing law clause is also forgotten. And the response to my clients are always, the reason why it's important to know what law you're applying to your contract is because if a dispute were to ever arise, God forbid, but it does happen, you want to be familiar with your rights. You want to be familiar with what you are obligated to give to the other side, but what you are entitled to get on your own. And we have been highly pushing the CISG because the CISG is this international treaty where jurisdictions from all over came together and put it together in a way that would be understandable to civil law countries, to common law countries, and also take into consideration not only the differences and nuances between these two types of jurisdictions, but also now the rise in trade and the rise in businesses worldwide. Different cultures are also coming to understand that there are certain damages or certain obligations that you never would have expected if you end up in court in a different country. So for example, in the US is quite famous for their liquidated damages or penalties, very, very high damages. Whereas in civil law countries such as Germany, you would never see that. So the CISG has taken kind of the steps or kind of taken the agreement between the parties and found the middle road. And that is something beneficial to small, mid-sized, large businesses because they will be familiar with what they can and will be faced with in a situation where a question arises in relation to a contract. So I think that's all for me. Take this opportunity to thank you. If you have any questions, I'm happy to answer it. Otherwise, I will try to stop this.
Thank you, Sherlin, at this stage. And benefits of alternative dispute settlement are rightly described. And you also elaborated the implications of CISG for effective alternative dispute settlement process. And thank you for the Hong Kong case. That is a learning experience for us. And we hope that we'll be able to respond to your suggestions on the governing law issues. Thank you. So now we want to move to our national segment. And we have with us Honorable former Executive Director of Bangladesh Bank, Mr. Mohammad Ahsanullah, and who is currently a supernumerary professor of Bangladesh Institute of Bank Management and an independent director of Meghna Bank Limited. He's having a master's degree in economics from Vanderbilt University, USA. He's a member of ICC Banking Commission Bangladesh and a senior consultant of SWIFT. Let us listen the central bank perspective of these issues from Mr. Ahsanullah. Sir, please, over to you.
Can you hear me, please?
Yes.
Okay. Thank you, my very affectionate moderators, Dr. Shah Mohammad Ahsan Habib, Senior Professor, Bangladesh Institute of Bank Management. And at the very outset, I owe my highest respect to Mr. Mahbubur Rahman, the chairman of the board of BIAC, who has not come up as yet. Maybe that will be coming later on. In fact, I feel honored to have been invited to speak a few words in this webinar of Bangladesh International Arbitration Center, jointly hosted with the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific ASEAN Republic of Korea. I pay my due respect to august presence of Mr. Kaiser Chowdhury, Chief Executive Officer of BIAC, Ms. Athita Komindr, Head of UNCITRAL RCAP. Due honor is also paid to the esteemed speakers, Mr. Luca, Castellani, legal officer, UNCITRAL, and Ms. Sherlin Tung, partner, Withersworldwide, Mr. Rahman, President of Dhaka Chamber of Commerce and Industry, Barrister Safayatullah, Head of Mutual Trust Bank Group Legal Affairs Division. Ladies and gentlemen, who are witnessing my deliberation in this webinar, a very good afternoon to everybody. International contracts are predominantly in black and white, based on mutual consent and agreement. The reason being, most of the contracting parties are not followed, likely to be physically known to one another, not to speak of the underlying risks involved against the wide array of transactions that take place to execute the contract. I do not like to dwell on alternative dispute resolution because the implementation status of it in Bangladesh is hardly up to the level of satisfaction. The losing party almost invariably appear to the court of law for redress, in spite of the fact that both the parties agreed to abide by the mediation of the ADR bodies. Nevertheless, the brief presentations made by Mr. Luca Castellani, legal officer of UNCITRAL, and Ms. Sherlin Tung, a partner with the Withersworldwide, Hong Kong, have been basically the epitome of CISG status and activities among its member states over the globe. They deserve appreciation for such a nice and precise presentations. Mr. Luca has clearly mentioned that the advantages that the member states might derive by using CISG. At the same time, he did not forget to observe towards the end, unfortunately, the CISG is least adopted where it may be needed the most. Very good observation. It is heartening to note that 94 states have already adopted the treaty, including the highly developed countries except most of the South Asian states. Even USA and China joined with some reservations. UK, Brazil, India, South Korea are learned to have not yet joined as yet, but they're in the row. There must be some reasons behind it, which I believe will be mitigated through discussion and through mutual understanding in course of time. You might be knowing that I had been in the central bank for more than 3 decades, mostly engaged in international trade related departments. In addition to formulating foreign exchange policies, how does they operate, and foreign exchange investment in these countries. Basically, I had to monitor international trade, more categorically export and import, whether export proceeds are being repatriated timely and input payments are made on value rate. Every after 3 months, I have to sit with the banks who are allowed to deal in foreign exchange, that is, authorized dealer banks for international trade. If the export proceeds are not repatriated in due time, it is suspected that there must be some reasons behind it. Maybe there is something in the export mechanism leading to siphoning out of money from the country under the garb of some unusual practices. However, the most common reasons why export proceeds remain non-repatriated are inter alia late shipment of goods by the exporting countries and the discrepant shipping documents. Conversely, if the import payments are not made on value date, there may be imposition of penalty for late payment, or suspicion might also be there of some unusual monetary fraudulent practices. In both the cases, the images of the country, particularly the banking sector as a whole, is badly tarnished, not to speak of the financial loss of the country due to ad confirmation for import LC by a reputed bank and rigorous conditionalities or even price card for exportable items. Ladies and gentlemen, Bangladesh, like only a very few countries of the world, did not adopt the CISG. The reason might be none of the countries in this region did adopt it. The reason why India is refraining from signing the CISG is that, in their opinion, that CISG is not a comprehensive treaty, having no relation to the validity of contract, like fraud, legality, so on and so forth. However, the question in respect to Bangladesh, which has been continuing its cross-border trade without being the signatory of CISG for long, whether the benefits as highlighted would outweigh the cost and formalities for settlement of international trade dispute, if any, once Bangladesh becomes a member of it. Given the development trade of Bangladesh and the vision to become a developed nation by 2041, the biggest benefit Bangladesh would derive to be the proud member of the international body like CISG, an organ of the United Nations, I mean the Vienna Convention, which I believe in times of any dire need, like international trade disruptions, would come forward to protect our interest. Moreover, against the backdrop of business-friendly FX policies now prevailing in Bangladesh, like the open accounts in the trade arena, the opening up of the capital account for investment abroad, the digital transformation that Bangladesh is undergoing in the banking sector, and the decision of the government for setting up 100 export processing zones for wooing foreign investment. CISG would be a comfort zone for the concerned parties. So, instead of keeping aloof, Bangladesh should seriously think of becoming the signatory or ratifying country of CISG to reap the benefits now prevailing and the benefits that are in the offing. With these few words, I'd like to conclude. Thank you very much.
Thank you, sir. Thank you for your experience and sharing your experiences and opinions. Now we'll move to our next speaker. He's basically representing the country's trading and business community. Let me invite the president of Dhaka Chamber of Commerce and Industry, Mr. Rizwan Rahman. Mr. Rizwan is the managing director of ETBL Securities and Exchange Limited, a director at Eastland Insurance Company Limited, and the Financial Express. He also served as director of Bangladesh Chamber of Industries and Bangladesh Philippines Chamber of Commerce and Industry. Yes, this is time for getting business and traders' perspective on the issues. Over to you, sir.
Thank you, Mr. Moderator. You forgot to give my most important introduction. I'm also a sponsor of BIAC, and I'm a member of the board of BIAC as well. So, of course, thank you, Honorable Chair of BIAC, who I'm fortunate that our chairman just joined as soon as I'm about to start speaking. Mr. Chairman, our newly appointed CEO, Mr. Kaiser Chowdhury, my fellow panelists, ladies and gentlemen, our friends from abroad who's joined us today, Assalamu alaikum and a very good afternoon. At the very outset, let me thank UNCITRAL and BIAC for inviting me. This is more of a learning session for me because I went through the presentations of Mr. Castellani and Sherlin Tung, and it was quite interesting because at the end of the day, we speak from the trade perspective and how CISG can actually, the adoption of the CISG for modernizing this commercial law, improving efficiency of the supply chain system, and establish Bangladesh as a key ADR service provider. Now, out of the $28 trillion global trade, which is a catalyst to support the global connectivity and the economic dynamics, Bangladesh alone has trade which exceeds over $100 billion, out of which $45 billion, many of you are aware, comes from our exports, which is exponentially growing at a rate of 15+%, even as of 2021 during the pandemic. So in tandem with this growth, the commercial dispute obviously has increased as well. And Bangladesh, as you all know, that is poised to graduate to a developing country, as the former Bangladesh Bank Executive Director mentioned, by 2026, which will result in various changes and challenges in the international trade landscape. Now, these growing concerns of trade disputes has made the ADR more important and more relevant than ever. So, of course, ADR has gained some popularities as an alternative means of settlement due to its confidential and informal nature. And of course, it does save a lot of time. Many of you, many lawyers here present today, you know, we are spending actually more than all of your career in the courtrooms because of the time-consuming efforts in the appellate division as well as the High Court and others. But due to the lack of complex structure and inappropriateness of different laws and related provisions and policies, I'm not a legal expert, but you know that because of these reasons, ADR in many cases cannot function properly. And it's also very true that Bangladesh hardly sees any sort of international arbitration. However, following the LDC graduation, the number of trade disputes is likely to increase by manifold. And therefore, we need to be equipped to tackle these challenges and amend laws or adopt internationally recognized conventions as and when required to ensure appropriate and effective dispute resolution for international trade, investments, and contracts. Now, the UN Convention on CISG, as well as some other principles on the international commercial contracts, were better positioned to protect themselves for these kind of trade interruptions. And of course, as we have learned from the various presentations today, that CISG is one of the internationally applauded conventions which may improve overall legal framework of the country related to the international trade and investments if adopted. However, Bangladesh is not a signatory or ratifying country of the CISG or the UNIDROIT, UNIDROIT principles for international commercial contracts. Now, Bangladesh is yet to sign the treaty, and the principles of the country also has not recognized the national regulation to cover the cross-border purchases of sales contracts. Now, implementation of this specific CISG, speaking from a chamber perspective or a trade organization perspective, it will definitely reduce the need for hiring foreign lawyers, the need of knowing foreign laws, reducing overall transaction costs for traders and investors all across the globe. Now, the laws are being updated regularly. Many lawyers here today, you know that the new income tax law has already been drafted. The new VAT law has been implemented just a few years back. And alongside, the business community is always advocating for updating corporate and advocates for the corporate as well as the bankruptcy laws. Therefore, it is important to decide how the CISG is going to affect these laws so that the entire legal framework can be streamlined. And additionally, we must identify the changes that are required by our international counterparts, how the existing laws are being accepted by them. That must also be identified. And it is also to be remembered that the CISG should only be adopted if it has more supports compared to Bangladesh's and its counterparts' existing legal framework. And to be honest, the business community has very little idea about the CISG framework. You know, we are an SME-oriented country. So when I mean the business community, the mass community, and the same is true for Bangladeshi legal experts, lawyers, arbitrators, and many others. So a large number of awareness and training programs will be required prior to the adoption of this CISG. And integration problems may also arise due to the differences in the legal framework between Bangladesh and the one on which the CISG is based. And it will be difficult to reconcile these differences. Now, yes, it is inevitable that CISG can offer justice. As mentioned earlier, CISG is actually a gap filler, and SMEs cannot afford expensive lawyers to frame agreements. And if the contract is adopted, it offers an internationally accepted framework and reduces the risk associated with trade. Now, the dispute-related trade is a common and growing phenomenon in Bangladesh, but the rationalization of the trade-related issues is critical to enhance our trade growth. And of course, you know that the Bangladesh has the Vision 2041 as visioned by our Prime Minister regarding the ease of doing index and, you know, the post-graduation challenges. Many things are put together. We have a 100-year Delta plan. And in this specific doing business index, enforcing contract is one of the most important parameters, and Bangladesh is unfortunately staying behind it. And we believe the effective incorporation of the ADR and the CISG would definitely step forward and ease enforcing contract to a large extent, resulting in sustaining smooth cross-border trade environment and growth post the LDC graduation. With these few words, I would not like to prolong my speech any further, but I would definitely sincerely request the BIAC, UNCITRAL, that this should be one of the many of your initiatives in the future, because we need to create more awareness. And needless to mention, the Dhaka Chamber remains at your full disposal for any sort of policy support or any sort of events required to create awareness within our business community. I thank you for your time and for inviting me here. Thank you.
Thank you. Thank you, Mr. Rizwan. Now, our final panel discussant, and he's basically head of legal affairs and Executive Vice President of the Mutual Trust Bank Limited, Barrister Shafaatullah. Mr. Shafaatullah is a barrister at law from Lincoln Inn and an advocate of the Supreme Court of Bangladesh. Please, Mr. Shafaatullah, this is time for perspective of the commercial banks, please.
Thank you. Thank you, Honorable Moderator. My regards to the organizers, UNCITRAL and BIAC. Amongst many other amazing initiatives, this is the latest of your initiatives, and I feel very proud to be part of this August speakers. One, I think two things come with speaking at the last. One is majority of the things are already spoken. So you have learned a lot. The other is because you have learned a lot from the speakers, then you can give your own perspective and share your views on this particular topic. Now, I would like to draw the attention of all the speakers, along with the audience, today's audience, CISG is nothing new. It was there since 1980. But till today, there are quite a few signatory countries. That's true. Majority of the countries who are signatories are, the first world countries, if I may call it. And there are certain problems also associated with it. Let me first of all give my perspective from the banking and also business point of view of Bangladesh. The advantages of being a signatory to CISG is that it has already been spoken before, is that it ensures safety and security of the banks and traders, and it can function as the guiding document in case of cash in advance, an open account, reducing country risk, an unbinding sales contract system, open account, cash in advance in back-to-back LC. ADR clauses can assure disputes and cost-effective and quick arbitration, not litigation, because CISG, ADR clauses are inbuilt in CISG. Uniformity, CISG and UNCITRAL principles is a matter of great comfort for the traders and other stakeholders through direct linkage and association between domestic and trade and cross-border trade transactions, help avoid the tricky conflict of laws issues. I think that's very, very important. Takes into consideration modern trade practices and realities, fair and does not favor the buyer at the expense of the seller or vice versa. Helps in the promotion of international trade by removing a substantial barrier of diverse legal frameworks. So these are the advantages. I think this has already come forward through the discussions. But what I would like to draw attention of this August gathering is this, from the perspective of Bangladesh, who is graduating to be, to be there in the scene, the world scene. Because of the 11A of the CISG, if the country, if the nation is a signatory, if both the nations are signatories of CISG, then whatever trade that happens between the nations, the parties, knowing or unknowingly, are bound by CISG. So that is something for Bangladeshi perspective, I would rather say. We need, of course, CISG is beautiful, it's fantastic. But perhaps before embarking on being a signatory state of CISG, we as Bangladeshi, as a nation who is, a majority of which is small and medium, and they are doing business, many of them are doing only LC documents. Many of them, the LC documents are not even supported by a binding contract, majority of which. So from that backdrop, if CISG is adopted by the states, it may be a little premature, my point of view, because parties may be unwilling to be bound by CISG since it automatically applies to any contract for sales of goods whose principal place of business is in different CISG countries. Especially Article 6 of the CISG allows parties to agree that CISG will not apply, but to opt out of CISG, either fully or partially. So Article 6 actually allows that provision. But in order for the parties to be able to do so, they need to be able to know about CISG in the first place. So I think there is much more to do in terms of education, in terms of trainings, in terms of enlightenment of our general business community at large. And then perhaps at some point, we may consider being a signatory. UCC requires any contract for the sale of goods priced at $500 or more to be evidenced by writing, or at least through electronic HTML record. There is no such requirement under CISG. Now, the most important part here, as per Article 16.2a of CISG, an offer cannot be revoked if it indicates, whether by stating a fixed time for acceptance or otherwise, that it is irrevocable. Hence, simply by inserting a time as to when the offer will expire, an offer becomes irrevocable under CISG. So that is something that we must look into from the perspective of Bangladesh, and also from the perspective of the small and medium entrepreneurs of Bangladesh. Few suggestions, if I may, in this backdrop. We may consider becoming signatory ratifying country of the CISG or UNCITRAL, which can result in being in a better position to protect itself during trade interruptions, but at a later stage, maybe graduating our community, business community, gradually making them ready for this huge transformation. rather than jumping into it. That is the first suggestion. Bangladesh should recognize national regulation to cover cross-border purchase or sales contracts, should include the arbitration clause. I think this is super duper important. We as lawyers and from banking perspective and from various other perspectives, we have seen that in Bangladesh, the business community, the local, the mass community, they're not aware of the importance and the significance of arbitration clause. They feel that arbitration is costly, it's more expensive. They feel that you go to court, you get a cheaper remedy, but they fail to understand that a civil dispute in Bangladesh courts takes about 6-7 years to be settled. So when you put the cost of time, arbitration is actually not expensive, it's very cheap and it's confidential and other benefits are there, but majority of the community are not aware of it. So we should graduate them on that. And then issue guideline on model contract to support traders and bankers in standardizing and assessing the sales purchase contract. Contract Act of 1972, that is the Bangladeshi Contract Act, should be upgraded and amended with certain relevant CISG and UNCITRAL provisions or principles. Through that, we can do the bridging. We do not need to be a signatory, but we can get the principles on board. So we may get best of both worlds. Unification of law through uniform rules, international conventions can help minimizing the information gap on regulatory and dispute settlement procedures amongst traders and bankers, arrange training, awareness, and capacity development events for the sake of handling relevant risk related to the applicability of a binding contract, importance of different contract clauses, dispute settlement procedures, applicable regulations in the sales purchase contract, absence of the arbitration clause and the compensation clause in the contract document is common in Bangladesh, which leave local exporters vulnerable to exploitation. This can be ensured through training and awareness regarding its importance. Contract Act 1872 should be upgraded because it has been a long, long time. Now, final words from the banking perspective. Well, as of March, let me give you some data. This pandemic has taken a lot from us, but also has given us a lot in terms of digitalization, in terms of making efficiency, making people and organizations more efficient. That is true. But there are some facts. As of March 2020, the global clothing brands and retailers canceled import orders worth $1.4 billion from the country as the pandemic hit the businesses badly, mostly in European and US markets. It said a total of 347 apparel exporters faced order cancellations worth $927 million, and 220 knitwear exporters faced cancellations of work orders worth $480 million. Bangladesh lost roughly $3 billion in export earnings and cancellations, terminations of contracts, purchase orders that were initially estimated to be $6 million. Binding sale contract may ensure the safety and security of the banks and traders. Bangladesh Bank, this is something as a suggestion, Bangladesh Bank being the regulator, may choose to issue a guideline on model contracts to support traders and bankers in standardizing and assessing the sales purchase contract. Bangladesh should include the arbitration clause and compensation clause in the contract document, which is currently absent in majority of the cases. For example, alternative dispute resolution clauses can assure disputes will be resolved through cost-effective and quick arbitration and not litigation. Traders and bankers have a lack of awareness and information gap on the importance of a binding sales purchase contract in the context of international trade transactions, not just the LC document, but also supported by a proper contract, which spells out many of the unspoken terms and many of the events which may happen. So the parties will be well aware beforehand, and definitely they must incorporate arbitration clauses and resort to institutional arbitration to avoid bias. And because you know what happens in Bangladesh, even in some cases you have arbitration clause, but these are not institutional arbitration. Like party A will choose his arbitrator, party B will choose his arbitrator, and both of them will choose to have their chairman. Most of the time, they don't get into consensus. So that is the problem. You see, that can be avoided by resorting to institutional arbitrations and can be guided through Bangladesh Bank. And through that, we may gradually develop ourselves gradually develop our level of understanding, and then surely resort to CISG. With that, I thank you all for listening to me, and thank you all. Thank you.
Thank you, Mr. Shafaatullah. Thank you very much. We have had fantastic discussions today, and we have received international perspectives, country perspectives, sectoral opinions, and some very good suggestions as well. Just let me ask you one question to Luca, or maybe Athita, any one of you. From where should we start the process for this ratification of CISG? Which one is the right stakeholder to start the process? How much time it would take to complete the process of ratification?
Well, thank you. This is a very, very pertinent question. And first of all, I would like to thank all the speakers, especially the colleagues from Bangladesh who expressed support for this discussion. We particularly value the questions like the ones which were just raised about the need to familiarize SMEs, and let's not forget also that the application of the CSG takes place in absence of another choice. So now there are two parts of this process. There is the domestic part and there is the international part. Once the international part is easy, of course, because it is like any other treaty. There is the need to deposit the instrument of accession with the Secretary General of the United Nations in New York. This is a standard diplomatic practice. And then once the instrument, which has to be signed by either the president or the prime minister or the minister of foreign affairs, depending on the constitutional practice. Once it is deposited, the treaty enters into force after 1 year. So there is still 1 year to get ready. Now, the other part is where I look at all of you as experts in the law of Bangladesh and in the constitutional law of Bangladesh to know what are the constitutional requirements to pass a treaty, which is the proper procedure. Of course, the case has to be made. Of course, as we do in our countries, we are very happy to support this discussion, but we believe that this should come first and foremost from the private sector, because it has to fulfill a need, real need of the private sector that wants to improve the standing of Bangladesh and also legal certainty and predictability and reduce the transaction costs. This has to go towards efficiency. What is very good news is that, of course, some significant transformation is going on in Bangladesh, including, I mentioned before, digital transformation. So in my opinion, if there is a political will, there is the possibility to finalize this process in a foreseeable time, 1 year, maybe maximum 2 years. I would like to say I have had a very positive recent experience with Bangladesh because Bangladesh last year has ratified a treaty that I had the pleasure to follow closely, to be one of the drafters. It's called the Framework Agreement on Paperless Trade Facilitation in Asia and the Pacific. And Bangladesh now is one of the 5 state parties, and in the end of April is one of the 5 states that will meet in Bangkok as the founding members of this treaty. And this, as I said, was done in a couple of years. There was a strong push from that part of the society, and the government was very supportive, and it went through, and now Bangladesh is a party. Now, if Bangladesh is a leader and a forerunner in paperless trade, I think it can very well be a leader in South Asia, at least in sale of goods, and catch up with the other 94 states soon.
Okay, thank you. Thank you. Thank you very much. We are at the final phase of our event today. Now, before moving to our final speech by the Honorable Chairman of the Board of BIAC, let me simply state that I think 4 key recommendations that we have received today. One is almost all the speakers, they're in one voice, they have mentioned the importance of ratification of CISG. Then second thing is about the need of standardization of contract and the associated kind of intervention of the policymakers. And another thing is that for greater implications, unification of the domestic regulations, that is our Contract Act, that is also came in the discussions. And finally, obviously, awareness development is a literacy on this particular issue. So thank you for all those comments and opinions. And let me inform you that as part of a government task force that was formed recently, that is represented by all the key stakeholders, we have already proposed for ratification of CISG, and that has already been placed to the Office of the Honorable Prime Minister recently, in few days back. So we have already started that process. So hopefully we'll receive a right kind of responses on the part of policymakers. Distinguished audiences, this is time for closing remarks. May I now request the current and founding chairman of the Board of BIAC, Mr. Mahbubur Rahman, for concluding remarks, who is an eminent businessman of the country and also the president of ICC Bangladesh. He's the only arbitrator from Bangladesh for the China International Economic and Trade Arbitration Commission. Mr. Rahman is the chairman of Island Insurance Company Limited, chairman and CEO of ETBL Holdings Limited, and chairman of the International Publications Limited and National Housing Finance and Investment Limited. Let me inform, he is the only businessman from Bangladesh to be listed in the 150 high impact leaders under the Creating Emerging Market Project 2020 at the Harvard Business School. So please, it is time for your final remarks. Thank you, sir. Over to you. Sir, I think it is mute, sir, please. Unmute it.
I think his screen is frozen. Someone needs to call him.
Oh, okay. Now it is okay?
Yes, sir.
Dr. Shah Mohammad Hassan Habib is from the BIBM. This, if I have rightly identified the moderator of this session, Hassan Habib.
Yes.
Am I right?
Yes, sir.
From Bangladesh Institute of Banking Institute.
Bank management, sir. Bank management.
Bank management.
Yes.
Bank management. Okay.
Yeah.
Thank you very much indeed for joining our efforts that we have jointly undertaken by BIAC and the UNCITRAL, with particular support of the chief of UNCITRAL in the Asia Pacific, Athita. Very difficult for me to pronounce properly. Athita, what? Komindr. Am I right in pronouncing? From which country?
I'm from Thailand, and your pronunciation is great. Thank you very much.
Thank you very, very much. Since it is your headquarters is in Seoul, I was thinking that whether you are from the Korea itself, but now that you are more closer to us than far away in the forest. Nevertheless, thank you very much. I think possibly this is our second initiative through you to host this webinar, and it is very, very helpful for us, more particularly, who are trying desperately to introduce ADR in Bangladesh because we are far behind in our course in this case, because our legal community, they advise their clientele to go to the court instead of going for alternative dispute resolution. And also, as has been discussed by many of our speakers here, as I have heard, that in many of the contracts, it is either verbal contract or only the letters of credit only. There is no formal contract in the market, and more importantly, the small and medium or micro industries almost nil. And for all these reasons, the alternative dispute resolution also has become very difficult because no one is binded by a contract as such. So from that point of view, we have been trying our best to go ahead with the support of the IFC, International Finance Corporation of World Bank. And for the last 10 years, over 10 years, we have been working relentlessly with the business community, trade bodies, the government of Bangladesh, as well as with the United Nations through you. And besides the other arbitral institutions in and around us, including the Permanent Court of Arbitration in The Hague, and your Thailand Arbitration Center is also our cooperation partner. And from that point of view, we have been working very relentlessly on this. I must mention here that despite our efforts and our arbitration rules are completely compatible with that of UNCITRAL rules, with that of International Court of Arbitration rules of ICC, in case of AAA, but in view of our location, being in an LDC country, now we are graduating to a developing country, they are just thinking twice whether this will be the right approach for them to settle the arbitration here in Bangladesh. Despite the fact that we have every facility to conduct such arbitration, and most independent, because all the trade bodies, the major and eminent trade bodies of Bangladesh are the sponsor and founders of this. As has been said already, the International Chamber of Commerce Bangladesh, Dhaka Chamber of Commerce in Bangladesh, Metropolitan Chamber of Commerce in Bangladesh, the oldest chamber in the country for 117 years old. So we are all having all this support and an independent entity. From that point of view, I would consider that your support of the UNCITRAL is very, very important for us to bring about a change in the total attitude, in the total situation prevailing in and around us. So from that point of view, I would consider that your such cooperation is going to be one of the very important milestone for Bangladesh Arbitration Center to go ahead with its aims and objectives, to go ahead and establish the ADR as the best alternative against the legal proceedings in the court of law. And we are also trying to amend certain clauses of our Arbitration Act, which are also sometimes becoming a detriment in implementation of the arbitral awards, and which are also being taken by the government very seriously. And I must say that we are at it, and the government is also very supportive from that point of view. So just as a formal part of it, I'm profoundly pleased to be here with you all in this event, as has been, and this has been jointly organized by the BIAC and the UNCITRAL, a Regional Center for Asia Pacific, We are thankful to UNCITRAL for their timely initiative jointly organized this important webinar for alternative dispute resolution and international sale of goods, time to benefit from the CISG. As you have already discussed about the CISG, I would not like to go into that part, but definitely we are in support of having this being ratified by the government of Bangladesh. And because Bangladesh, if you remember, Bangladesh signed the treaty, New York Convention, in 1972, but as in luck have it, we have ratified it in 2001. We signed it in 1972, but ratified it in 2001. So they're very, very unfortunate from that point of view. So CISG, as you have said, that more than 90 countries has already adopted it and ratified it. We will definitely try to see that the government goes and shake hands with the rest of the countries here in this case. This webinar was arranged to explore and understand the application of the CISG and the Uniform Sales Law, including the benefits of dispute resolution from various perspectives. I must say that the deliberations of the panel discussions have been most absorbing and informative. I understand that as of now, United Nations Convention on Contracts for the International Sale of Goods has been ratified by 94 countries, as I have said already, representing 2/3 of the world trade. Recently, Hong Kong is progressing to adopt this convention and currently is the only country desiring to align themselves from this region. Very, very important because Hong Kong is the hot seat of trading in the Asia Pacific. The Hong Kong is of the view that it would promote its trade with civil law and common law jurisdictions by way of application of uniform rules on sales of goods. It is also their expectation that it would add significant certainty and predictability to international sales contracts. I'm sure that this webinar has given us the opportunity to collectively explore and understand the added benefits that Bangladesh may enjoy if it is adopted the CISG Convention. For instance, we can benefit from the uniform regime for out-of-court dispute settlement that CISG provides for international sale of goods. This will introduce greater certainty in commercial arbitration and commercial transactions. We shall forward the substantive findings of this webinar, as I have already mentioned, to the respective authorities, but more particularly to the Ministry of Law and Justice of the government for their review and favorable consideration to ratify this convention. My thanks and gratitude to the head of UNCITRAL Regional Center for Asia Pacific, Athita Komindr, for gracing this occasion. And I will urge upon her that please do keep us in touch, and for all days to come, that we need your support in order to bring about a total change in the ADR landscape in this country. And I also would like to take this opportunity to convey my heartfelt thanks to the panel of discussions of today's session, Mr. Luca Castellani, Mr. Sherlin Tung, Ms. Sherlin Tung, Mr. Muhammad Hasanullah, Mr. Rizwanur Rahman, the President of the Dhaka Chamber of Commerce, Barrister Shafatullah from the Mutual Trust Bank for their articulation and valuable contribution. And many of them are involved in the process of the alternative dispute resolution, as you have heard that the major trade bodies of Bangladesh are the founders of the BIAC in Bangladesh, having no personal matter to be settled. And my sincere appreciation to the moderator, decision Shah Muhammad Ahsan Habib, Professor, Bangladesh Institute of Bank Management, for for conducting the proceedings of today's session with such enthusiasm. And last but not the least, I must say thank you, Kaiser Chowdhury, our new CEO. Athita, you have seen him for the first time, right? Last time you met Rumi Ali. But I would also, I'm also very, very happy to announce that in our last board meeting, Rumi Ali has been elected as the vice chairman of BIAC, and he has been nominated to the board by the ICC Bangladesh. And so now he is the vice chairman in the BIAC. We did not allow him to leave the organization. And so therefore, he is also with us and continuing in different capacity. Nevertheless, I must say that your participation and also the distinguished speakers who has been very kind to spare some of their valuable time with us. And if all such support that we continue to receive, I think in no distant future, we are going to make it a very, very important institution out of the court settlement. And this is the only government licensed arbitration center in the country. And we look forward to your support and cooperation. And some of the members of the legal community has been providing us support. And with their support, we are also proceeding in the process. And some of our arbitrators in the list are also in the list of Permanent Court of Arbitration in The Hague. So this is very, very important from that point of view, and we look forward for your continuing support in this case. Thank you very much indeed.
Thank you, ladies and gentlemen. This marks the end of today's webinar. We thank our co-host, UNCITRAL, RCAP, our moderator, our panel discussants, and all our distinguished guests who have joined us via Zoom, Facebook. We hope to have you all with us in our future events. Stay safe. We're signing out. Thank you.